All right, so we actually are talking about our legal and policy implications of storing data on Filecoin, some legal insights for the Filecoin developers. So I'm going to be talking about the myriad legal issues that can arise when storing other people's data. So first I'll introduce myself. So Kurt Opsahl, I'm the Associate General Counsel, work on policy issues at the Filecoin Foundation. My background, I've actually been interested in this area for a long time, and my law school had a thesis paper called Freezing Rain on the Internet Superhighway, some metaphors that have not aged particularly well, but remain a live issue for online intermediaries. And I represented many of the early dot-com internet companies on issues like privacy, copyright, and user-generated content. Been working in peer-to-peer distributed systems file transfer since the Fast Track protocol, which was around popular in the early 2000s. And I was previously the general counsel at the Electronic Frontier Foundation, which is a NGO that fights for digital rights, privacy, free speech online, and founded in 1990 in an era of BBSs more than the modern internet as we know it. Some caveats. So I am a lawyer, but I am not your lawyer. This is an overview of many complex laws, and the devil is in the details. So this is a sort of the big picture. How it actually boils down to your situation is an interesting question that is best for a privileged conversation with your attorney. And I'll have some time for Q&A at the end. So let's start with the overview. So data storage for users involves the possibility that some of them may want to store some data that raises legal issues. And the good news is that many jurisdictions have recognized that this can be a problem, and they have provided protections. So law and policy generally recognize that the soapbox should not and is not liable for what the speaker has said. The internet has made things more complex, though. So, like in earlier eras, there were a lot of intermediate or communication systems, and no one sort of seriously thought that, like, the telephone or telegraph operator should be liable for what someone transmitted on there, or if you were providing like a storage space, a physical storage space, and a locker where someone would put stuff, that you would be liable for whatever they did in there. But as things got onto the internet, many policymakers started to look at service providers, especially large centralized service providers, as a one-stop shop to help them solve problems. And they started to put some obligations on those sort of centralized points as a convenience matter, though the good news for a decentralized system is many of those obligations have limitations of size. So why does all of this matter? So liability limitations help innovation and development. The users benefit from having the availability of many choices and third-party services, but the issue is it's hard for providers to scale, doing gatekeeping, doing due diligence on all the information that might be stored. The cost of review, analysis, and decisions about whether or not something is good or bad is pretty expensive. And as we get to a point where storage and online services in general are getting less and less expensive per user, that like you might make a very small few dollars for storing a one page file, and it would cost you $500 to have an attorney think about it for a little bit to decide whether it was good or not. This is not a good recipe, and so it's very hard for a small company to try and do that, and it makes it inefficient. So you have too much expenses on startups trying to do this, and also the incentive is to be cautious when the cost of thinking about whether to take something down is expensive. You just remove it, or you try to make sure it never gets there in the first place. And that limits the ability of the system to work, to function, to achieve some of the benefits it has, as we say here, to preserve the world's most important information. Very hard to do if you have to have this liability review. So what are policymakers thinking about? Well, they're looking at several sort of somewhat competing interests. They want to support innovation, most of them, and economic development, and many recognize that the threat of liability will slow innovation. That it will hold back the industry, but they also have a strong interest in preventing harm and using the threat of liability to incentivize intermediaries to do this job that they'd like to see done, to get rid of bad things. And free expression also comes in. I would say that many countries, they want to enable a space for unfettered discussion and debate to help with free expression, to help with society, though there are definitely other nation states who are more interested in maximizing control over the discourse. So some of these are inherent tensions. I mean, you can summarize it really well. What do you want to do? Well, we want to stop the bad and allow the good. Very easy. You just make sure it's always only good information and never bad. But this is very hard to do in practice. What is good is an interesting question. It's not that, a binary system. It's one or the other. There's a spectrum between what is good, and there's like a category that sometimes, people refer to as lawful but awful. There are some kinds of things which are, protected expression, or there are legal things to say, but they still are fairly awful or cause people to be upset, cause tensions and issues. And that is also part of the spectrum that comes into play when policymakers are looking at online services. And then comes the question, who bears this burden? The burden of detecting whether something is good or bad, or detecting that there's a problem in a particular place? Is it the provider who has to look at their own things? Is it when someone else finds it and sends in a notice? Should the government be looking? Should it be private parties? The determination, what is the process to figure out where it falls in the spectrum, whether it's on one side of the line or the other? Is there going to be due process where it is really evaluated? That's time, a certain time and expense to provide that due process. Or is it going to be a summary system which is very efficient but make mistakes? Removal, is that the solution? You take it down. Do you have a process for putting things back if they're accidentally taken down? And then what do you do about redressing any harm that has occurred? So to some practicalities. One is that long-term cold storage will rarely cause any issues. Most of the attention is on live data that is available to the public and widely accessed. They are looking sort of where are things going to have maximum problem. It's when it is widely accessed by a large number of people brings the attention. So lower risk types of data that have lower risk, public databases, factual compilations, public domain materials, a user's own data where they have all the ability to have the rights to it, the consents necessary, and so on, have that level of control. These things are relatively low risk, but then still problems can occur. And so a word about jurisdiction. There are many jurisdictions. And we're certainly not going to cover them all today. The good news is not all of them are going to be relevant to your particular scenario, but there will be some key jurisdictions like where you live, where the hardware or the actual operations occur, where the customer lives or is doing business, and where the harm occurs. And just a little perspective on this is this is one of the incompatibilities with traditional legal norms with a decentralized network world, is the traditional legal norms are based on the nation state and the nation state's borders and jurisdictions and who's in charge of one or the other. And it was built in eras where travel was much less frequent, businesses were much more localized, and nation-state sovereignty was the cornerstone of international politics. But that also makes it confusing when you have a worldwide decentralized system with players in many different jurisdictions. So what areas does the law look at most? So privacy, and what we're talking about today, privacy in terms of data protection. And this is, what kind of permissions are necessary or consent for using, storing, processing personal information, dealing with the right to remove or the right to be forgotten. Intellectual property has been also a key driver of some of the liability issues, particularly copyright. Speech and content, also a huge issue. Content moderation, there's unlawful content, harmful content, which might fall into that sort of moving on the spectrum towards lawful but awful, or sometimes it is illegal depending on your jurisdiction, and social issues that arise from concerns about like disinformation or the spread of messages that some players in this don't like. So we'll start with privacy. Most, about 70%, according to this 2021 survey, have some form of data protection laws. Now, this is really just whether they have some form. You'll see that the United States there is green, indicating it has legislation. But that is not, there's no nationwide comprehensive data protection legislation in the United States. There are some states that have it. There are some categories of information that are protected. So this is whether they have any at all. But as you can see, a lot of them do, and a lot of the more significant countries. The GDPR, the General Data Protection Regulation, out of here in the European Union, is the most prominent. It was one of the first significant data protection legislations, and it is affecting one of the major economies, and it is very broad. Like, the category of what is personal information is personal data, and the rules relating to the movement of that data. Actually, we'll get to the definition in a second, but it's trying to establish rules that will protect information when it's being processed, stored, transferred, and make sure that it forms with these very high-minded principles. And storage is a form of processing. So it's one of those things that sometimes when I refer to processing and data protection, people think of that more as doing compute on data as opposed to just simply storing it. But under the definitions of the EU, that is processing and storage are inclusive. And it has a very broad scope in jurisdiction. We were talking about jurisdiction before. Well, the EU is trying to protect people in the European Economic Area, but also EU citizens wherever they are. So as a US citizen, now that I'm here in the EU, I am protected by the GDPR. When I get back home, I am not, but a EU citizen who comes with me to America remains under the jurisdiction. Now, just because a country says it has extraterritorial jurisdiction does not mean that the other country agrees and will do anything about that. But nevertheless, this is what the EU asserts. And so they have a number of user rights. You have the right to access your information, rectification, as they call it, which is a fancy way for saying correcting incorrect information. The right of erasure, or in some cases called the right to be forgotten. And data portability, being able to move one from another to try and encourage interoperability. And this applies to the personal data, so there's a broad definition for personal data. So it's any information related to an identified or identifiable natural person. So the identifiable is trying to get at pseudonymous information which can be traced back to the original person. So encryption can help with that if it is encryption that cannot get back to an identifiable person. But if it's encryption where the provider holds the key and could get it back to its original format, or it's really weak encryption and someone could break it and get back to the original format, then they are identifiable. And then one other point on this, and I think this applies to actually throughout the GDPR, providers can have a legitimate interest in processing information. So it doesn't always have to be based upon consent. There are cases in which the law will recognize a legitimate interest to process the information, whether or not someone consents. So turning now to intellectual property. So as I said, copyright is the most prominent, and this came to the fore with early days of peer-to-peer file sharing. As the availability of bandwidth to the consumer increased, and to the point where it was relatively easy to download a song, people started to do it quite a bit. And this got the recording industry up in arms. Bandwidth increased further, making it viable to start downloading films. And so the film industry started to get involved and went very hard after the early peer-to-peer networks. They took out Napster fairly early on, some other projects, and I was involved in some of the defense on this. Managed to survive the legal challenges for a number of years after by designing systems that were compatible with existing law, which was under a concept of capable of substantial non-infringing use, which all these networks were. They could be used for a wide variety of non-infringing purposes. But it went up to the Supreme Court, and they created a new law, or a new interpretation of the law that made those theories no longer viable. So I guess somewhat gratifying that they were legal under the theories that existed prior to that case, but not nearly as gratifying as winning. So other forms of intellectual properties are less of an issue. Trademark does come up quite a bit, but it is very much focused on the sale of physical counterfeit goods, that people selling, Louis Vuitton bags without paying Louis Vuitton. And usually that is a procedure to take down the domain name or the seller as quickly as possible. And even less frequently is a concern. There are other things like rights of publicity. I also mentioned database rights here. In most jurisdictions, there's not a intellectual property right in factual information. Facts meant to be free is a common thought, but in some places the compilation of facts all together in one in the form of a database are given sort of intellectual property-like rights. And then the broad category of unlawful content, and this is where there's actually a fair amount of variance as to what makes it. Defamatory material is commonly an issue. These are by defamatory, or sometimes called libel or slander. These are false statements that are harmful to the reputation of another person. And then another one that comes up quite frequently with a lot of variance, adult content. Different countries have different views as to what is necessary. Many rules will be about restricting access, so it's not unlawful per se, but it may be unlawful for certain people to below a certain age to view that material. And then there are some categories that are prohibited. Universally, child sexual abuse material, or CSAM, is unlawful. Obscenity, generally unlawful, but maybe some variation as to what is considered to be obscene in that jurisdiction. And then there are some countries which are a little bit further along the spectrum and are trying to remove indecent material or pornography of any type. And then plenty of other categories of unlawful speech. Hate speech, incitement, terrorism, extremism, insult. Insult is sort of like defamation, except it might be true. Lèse majesté, which is insulting the king, whether it's true or not. And a lot of variance as to what these are and how they are used. And some countries may decide that the opposing political party in their system are extremists and can no longer speak online if they are a particularly authoritarian regime. Some of these, of course, many of them are signatories to international human rights law that should prevent that kind of abuse, but not everybody who's a signatory of human rights law abides by it fully. So, now let's get to the protections, or the good news. So, most commonly, there are protections that are available under a notice and takedown regime. If a provider is get notified, and in some cases, the way in which you get notified is important. You can only be notified in a proper manner to be sort of liable for knowing the result by either the harm party, or perhaps it's the government, or in some cases it can be any party that decides to notify you. You're now on notice. And then you have to remove the material within a period of time. And if you do so, you're in a safe harbor and you're not liable for the bad stuff. And I think the better way of doing this in a more thoughtful countries will also add a counter notice and putback procedure, where if somebody has notified about content that you think is in fact lawful and should be allowed, you can counter notice and say, actually this is cool, and then the service provider can put the material back up after going and still have the safe harbor. This process can be misused. I mean, even if you have a counter notice and putback process that works very well, there is a gap, a time delay. And if you want to hassle somebody and remove their speech from online for at least a couple of weeks, you might be able to do that, whether or not you have a good claim. And perhaps, given the timing involved, 2 weeks is maybe all you need to accomplish your goals. There are processes where you can go after people who have misused it, who have put up false notifications, but in practice those have not proved to be particularly effective. As I said, there are many, many jurisdictions around the world. We're going to focus for more of a deeper dive on some of the largest economies, in particular the U.S. and EU. One is that there's a lot of companies in there, so a lot of the prominent intermediaries or the users are in those jurisdictions, and many of them have adopted the policies that are set from those jurisdictions for their worldwide audiences. And these policies have provided guidance to other countries, or at least an example of what has gone before, where other countries may disagree and modify it to suit their local conditions, but as being sort of the prominent one being followed by the most significant intermediaries, it is at least a starting point for thinking about it for a lot of countries. But I would note that while there are a lot of similarities, there are also some substantial disagreements between the U.S. and the EU on how to do this. And I think one prime example in speech concerns is in the United States. There's the First Amendment, which is protecting freedom of speech, and it allows for hate speech. In the EU, hate speech is unlawful, and that is a sort of fundamental social and political distinction between the attitudes on free expression between those two very large economies, and makes a difference in their regulations. Also, one of the largest economies in the world, China, has a very different approach. They have a lot of strict internal controls as to what can be said on systems inside of China, and then use technical architecture to try to shield their population from what goes on outside their borders, and to control the information space through technical means. And then a final note on this with that some countries who have noted that these rules will change, and sometimes a lot of their citizens' data is stored under other jurisdictions where they don't have control over what the policies are, have tried to institute data localization laws to require companies operating there to localize the data in that jurisdiction so it is clear that they have control of it. For example, Russia. If you are doing business in Russia and you're not storing your data in Russia, you can get fined or eventually put out of business. So we'll go into the United States, and I'm going to start out with something which is a bit of a rarity in U.S. Law, more common in some other places, but a stated set of policy objectives that were written into the statute. So a lot of times they will give some speeches on the floor about the statute, but actually writing it in is fairly rare. And some of these things, if they were in fact done, would be a really good part of policy. So some of the findings that the internet services offer users greater control, and there's a potential for even greater user control in the future as technology develops. And they will develop best with a minimum of government regulation. And to do so, they want to preserve vibrant and competitive free market, unfettered by federal or state regulation, and develop the technologies which maximize user control. So many of these principles would actually point to some of the things that we as a community are working on for decentralized user-based control systems. However, just because an earlier Congress put that into the statute does not control what a future Congress may do. So I think putting this out here more as like an aspirational statement of what I think some good policies might be, but I can't tell you that this actually is legally required just because they put it in the statute. So starting out with the substantive law for protecting intermediaries in the United States, Section 230 of the Communications Decency Act. And I got a segue on that. The Communications Decency Act, well, you can tell from the name that there's a lot of, it's about decency, and indeed it was. It was a law passed to try to make sure that the internet was a nice, decent place with no indecent material, family friendly, and PG at most. Well, so it turns out that was unconstitutional, and it was fairly obvious at the time, but nevertheless. Also, to be honest, when this passed in 1996, even then, there were corners of the internet were not decent. But it was unconstitutional, it was struck down, but Section 230 of that law was not struck down. Only parts of it that were regulating it. And Section 230 was designed to address one of the issues that there was a legal notion for a while that if you took some editorial control, if you made decisions about what stayed up, what went down, then you were taking ownership of those decisions and would be liable if those decisions went badly. And this would highly discourage some of the providers at that time from getting involved in making those decisions and undertaking the liability because they would prefer the immunity. But this is for some of the reasons we talked about earlier, you don't want to sort of discourage this thing that they want providers to make these decisions for them, especially since the providers can remove content that is objectionable but lawful, and law cannot. So they said, great, what we'll do is we'll give you this protection that you used to be able to get and allow you to take things down without losing that protection. So it is a very good law for protecting service providers, and notably, it is not a notice and takedown regime. It's just you got to work it out with the person who posted this information. The provider is just simply not responsible. And so it covers a lot of different things, and I think it was responsible in great degree for the U.S. and in particular sort of .com boom in the Silicon Valley, being able to have these startups have from like 0 to like 1 million customers and not undertake tremendous liability burdens. It was part of what made that thrive there. So it covers, I say, almost asterisks. The asterisks, not quite everything. So nothing about criminal law. That's getting to obscenity and child sexual abuse material. Privacy laws were not touched by this. And because of the powerful copyright industry lobby, no protection against from any law pertaining to intellectual property. So that was the deal that got it passed. So let's then turn. What happened with intellectual property, or copyright in particular? So a few years later, they passed the Digital Millennium Copyright Act. And it provided a notice and takedown regime. So there were protections for a couple of categories: conduits, system caching, user location tools, which is their fancy way of saying search engines, and storage at the direction of user, which I'm highlighting because of the connection with Filecoin. But it provides a notice and takedown process. So the copyright owner notifies the service provider's registered agent, and as a note, one of the things you have to do is register an agent. So there are some procedural steps there. The notice has to contain, there's like a list of information that it needs to contain to be a proper notice that would enable the recipient to identify the materials. And so you can't be just say like, the movie Godzilla, somewhere on your site, take it down. You have to be at this URL is where the movie Godzilla is. We are the copyright holders of the Godzilla movie, and then if they do a compliant notice, then they take it down. The users can counter notice and say, no, this is actually, a parody of Godzilla. It was a fair use. It's not your copyrighted work. It's allowed under law and should go back up. And then it has a procedure for misuse or misrepresentations. If the person who gave the notice made material misrepresentations to bamboozle the service provider, you can sue them for the damages. Again, in practice, that has been ineffective at dealing with the bad takedowns, but it is there in the law. And so we can't go into all the details, but I borrowed this graphic from the Copyright Office, a good summary of how it is. So if you take a look at this, if you are a mere conduit, so this is more like the pipes, very high level, you're running like fiber optic networks across the country and such, and it's just passing through, you don't have to do very much at all, and there's no notice and takedown. If you are involved in caching, there may be a notice and takedown, but you are presumed to not have knowledge, or you don't have to have these things. If you are hosting it, that's more where the storage providing comes. There are some knowledge standards, and you can get knowledge from notice. Notice is not needed if you have actual knowledge. So if you actually know that Godzilla is on your site, you don't have to, and maybe the person who put it up there, or you sell it and put it on the front page and say, come to my site, we got Godzilla. then that's actual knowledge and they don't have to give you the notice. But for the large part, you don't have a duty to monitor, and you can just let it happen and wait till you get a notice. So let's flip to the European Union. So they had the first one was the e-commerce directive, a number of articles setting out liability exemptions for intermediaries and service providers. Certain types of contracts were conditionally exempted, so mere conduit, similar to the U.S. law, and caching also similar. Then we have hosting. Hosting is, again, where storage is. And so it prohibits the member states. So there's, UUI directive, there's sort of a directive that goes out to the member states who then have to enable this in the national law. But they prohibits them from imposing a general monitoring obligation. So this is a very good thing to not have an obligation to monitor, though it does allow for certain limited, very specific monitoring laws in cases like, in some cases has been, well, this is coming up with chat control, for example, whereas it would be a specific monitoring law. So hosting is where an information society service, so also they have the different definitions of what a provider is or what the baseline is, but information society service is sort of a way of saying ISP. And if they do storage of information provided by a recipient of the service, a customer, then they're a host. And a host is not liable without knowledge or if they're not aware of the facts and circumstances where it's apparent. And that's trying to get at the, don't turn a blind eye. If you have all the information and you know about it, that would be absolutely obvious or apparent, I should say, it will be apparent, then that's the same as knowing. And then upon obtaining that knowledge or awareness, takes action to remove or disable it. The more recent Digital Services Act drilled down and tried to harmonize rules on how to remove it. So this one, the first said, there's an obligation to remove under these circumstances. The second bill is, okay, how do you do that? And trying to harmonize that across the different countries. And just as a side note, again, we were just hearkening back when we're talking about how many jurisdictions they are and different standards. Harmonization of these laws is very useful to a provider because then you can just have a process that is the right process over a wide variety of jurisdictions, and you don't have to custom create things for each individual one. So it is a useful thing for a provider to have harmonizations, and they were harmonizing it within the European Union. And as the EU likes to do, it's designed to have extraterritorial effect. So trying to get not just the people within the European Union, but also companies that target activities towards the European Union. And one of the reasons why the European Union is keen on this extraterritorial is many of the services that are widely used, the gigantic big tech companies, are not in the European Union and have a lot of effects in the European Union, and so they want to make sure that they can say that they have an effect on those companies. And then they also are tiering the regulations between different types, intermediaries, sort of as a base level, hosting providers, one up from that. Online platforms is when you're both holding their content and doing something. We'll get to a little bit more detail on this. And then very large online platforms, or VLOPs, that is their way of referring to Facebook and Google and sort of the large big tech companies. And so we'll just go through the tiered service and to sort of focus on the difference between hosting and online platforms is the online platform not only hosts the material, but also disseminates that information to the public. So if you host it and then it is just picked up back up from the person who put it there in the first place, but it doesn't go to the public, that is a host. If it is placed there and a hot storage situation where it is available to the whole world to look at, that goes into the online platform category. And if you look at the chart there, the pyramid, flipping between those two categories adds a few more regulatory requirements to have complaint handling, dispute resolution. Trusted flaggers is to identify like a set of people who can look through the publicly available information and tell you that it's bad. And the idea behind trusted flaggers is to mitigate the people who will flag things that is not actually unlawful content because they don't like that content or they want to cause trouble. So a trusted flagger is one that you think is not going to do that. They're going to be honest about what they are flagging. So the general due diligence, that applies to everybody, that they have to have a point of contact. They have to put some information in the terms and conditions to let the users know what's going on. And they have some transparency about their practices that also need to be reported. As you go up to the hosting service level, there is a notice and action procedure, which is their way of saying notice and takedown, or at least the action would be making a decision about whether or not to take it down. Must inform the decision to the user and why. And the and why is also sort of a more of a trying to get more transparency in why. This is a more recent law, and at the time it was coming about, people were starting to feel that there were opaque decisions from service providers who were just saying, we've decided to take down your content and we're not going to tell you why. And so we're trying to address for that. And then also under the Digital Service Act, users can challenge the provider's decision about whether to take it down or not. So there's a redress process. So I'm going to go to where we're going. Like, we're building a future we would want to live in. And this is, I get on my own soapbox, but I think intermediary protections are necessary to build that better future because they protect innovation, development, and fundamental rights. These protections are under fire. Policymakers are mad. That's a vast oversimplification of the complex relationship between policymakers and big tech. But they're upset with big tech for a variety of reasons, and they want to remove or reduce the protections that the big tech companies enjoy as an incentive, or threaten to remove them as an incentive to change their behavior, or remove them as a way to penalize. I think that the decentralized web is a better way to address the big tech opponent, to give people real choices so that they can move away from those companies, because if we remove these protections, that will make it more difficult for smaller providers, for decentralized providers, to be able to compete with big tech, to be able to provide their services without having the possibility of crushing litigation. And so it is vital to keep these protections in place, or at the very least, keep them in place for the smaller providers, the ones who are coming along and can provide the competitive environment that hopefully will bring us to a decentralized web where we don't have big tech centralized companies providing all the services.